Hi, everybody. I'm Samantha from the law offices of Samantha Wolfe, and we're here today for our virtual seminar. We try to do these monthly and talk about relevant topics for our clients that might affect you personally or those of you who have loved ones that this would affect. So I do have a PowerPoint presentation. We're going to go through those slides, and then we will have a question and answer session at the end. So Jeff, let's go ahead and share our screen. All right, so this is our office. We're located at 20 East 6th Street in Suite 206 in Waynesboro, Pennsylvania. You can reach us at 717-655-2676, and you're always welcome to call. We do offer free initial consultations. So today, what we're going to do as part of our series where we do monthly virtual seminars, which is the reason we do it is all part of our mission statement. We really feel like it's part of our job as either your attorney or maybe you refer clients to us. We always want to make sure that we are providing educational things to kind of keep you updated on what's happening in the law, talk about other planning techniques that you might not be aware of. So we always like to show you our mission statement just so we can explain why we do what we do. Today's topic is living at home at 50 could be a good thing. And let me explain a little bit why we thought of this topic. So what we try to do is kind of take a pulse of what our clients, what questions they're coming in and asking, what situations we're seeing more and more of. And it used to be that we had a lot of children as their parents aged, that they would be the main caregiver or the main support for that family. Now, right now, we're in a little bit of a transition period. We are seeing more families spread out where maybe kids live in different states and they aren't here locally, but we still do have a good base of clients who their families around them. And so we wanted to talk about very special planning techniques that can help when you do have a loved one who is your main caregiver. And so that was what kind of inspired this topic. So what I'm going to do is I'm going to give you some information, and then the best way I feel like to communicate these topics or these ideas would be through examples. So we have a couple of examples that we'll go through at the end. So let's start off with talking about family caregivers. So in our office here, we see most of the time it's children or grandchildren who are providing care for maybe an aging loved one. We've also seen it in a few situations where maybe it is an older individual who's providing the care. And we see that a lot if we have individuals with special needs, or if we have situations where there has been some sort of event where maybe a loved one is providing care for a short period of time. So we wanted to talk about a family caregiver agreement. So know that in any situation where there's a loved one who's providing care, we recommend a family caregiver agreement. And what this is it's an agreement that is valid, it's legally binding, and it's an enforceable contract, usually between an older person and someone else. And this is regarding care and living arrangements. So we do always put it in writing. Now, the importance of this, because the question I get asked a lot is, why do we have to do this? So more often than not, the situation we run into is I have maybe a child and a parent coming in, and maybe they're doing some estate planning or some nursing home protection planning. And during the course of the discussion, somebody asked the question about how maybe mom or dad has been transferring funds to pay the child for providing care for them. And so we always have to have this discussion. So know in Pennsylvania that there is a presumption that if money is being transferred between family members, that it's actually a gift. So if it's any amount over $500 or more in any 1 month, Pennsylvania is going to presume that that is a gift. And when we have a gift involved, there's a transfer penalty. So a lot of what we're talking about is trying to avoid the look back period or the transfer penalty period. Because again, the presumption is if it is a loved one, and that means whether it's a child, grandchild, it could be a son-in-law, daughter-in-law, whoever is providing the care, if there's a familial relationship between the two individuals, Pennsylvania, for long-term care purposes, will presume that any exchanging of money back and forth is a gift. So we have to be aware of that. Anytime that a gift is made, it's going to trigger a look back period, and we determine the ineligibility period. What that period is the period of time in which Medicaid, which is the government benefit, federal, that's funded then through our states, that provides long-term care, and Medicaid program covers that care if you meet certain financial and medical requirements. So when transfers happen, it can really mess up whether or not you're eligible for Medicaid benefits. The other thing it does is if you're making a transfer to a child, so let's say I'm providing care for maybe my mom or dad, and they're giving me so much money a month, but I don't have a signed family agreement, a caregiver agreement in place, then again, if my mom would ever be applying for Medicaid, then they're going to say that that's a gift, and that may then affect when she can get paid or when she can receive Medicaid benefits. Furthermore, it also makes me financially obligated to pay for my mom's care unless we can rebut that presumption and say, no, this was not a gift. This was not a transfer in that way. And so that's why we kind of start talking about caregiver agreements. So the purpose of the agreement is to rebut that presumption. So if we have a signed caregiver agreement in place, what this is saying is that if there is money being transferred from the individual to the person who's providing some sort of care, then it's not considered a gift. And that means that if that individual would ever need any type of long-term care, Medicaid is still an available resource to help pay for that. So that's the purpose of this agreement. Now, typically it provides provisions on who's going to make meals, who's doing the cleaning, the laundry, any maintenance or home repairs. It kind of outlines all of that. And all of that information has to be in there in order for it to be a valid caregiver agreement. So it's really important that when you're doing the agreement, that you make sure that you're talking through it with the attorney and talking about what tasks are going to be performed, what's required, how many hours a week. So family caregiver contracts are also called personal care agreements, elder care contracts, and personal services contracts, and they're written between a caregiver and a care recipient. While the contracts are usually between family members, such as elderly parent and adult child, it's not required that the two individuals be related. So I will tell you that I had a situation where we had a mom who was suffering from dementia, and there was some farmland that was involved in this, and the family really wanted to try to protect that farmland. Well, the issue there was that it was in mom's name. It wasn't her primary residence, so we couldn't exclude it. And so we had to think of ways that we could keep mom at home and still provide the level of care that she needs. Because the reality is that the average cost of nursing home skilled level care 24/7 in the facility is $14,676 a month. So when we're thinking through that, it can really financially cripple a family, especially those who are relying on those funds. And so what we did in that case is we were trying to think of ways that mom could still get the care and support she needed while still staying at home. And so in that case, what the daughter-in-law did is she found somebody who provided private caregiving services, and she did a caregiving agreement that just stipulated the hourly amount and the number of hours a week that this individual was going to come into the home and provide care. And the reality is that the cost of care, if you can have a private caregiver come in, is typically going to be less expensive than having skilled 24/7 care in the facility. And a lot of that's because you can just target the time frame in which that person may need the care. So maybe they don't need it at night, but they only need it for certain periods of time during the day. And so usually you can really lower what the care cost is if you can do a caregiver agreement. So these caregiver agreements are important in family settings because it rebuts the presumption that it's a gift. So you absolutely need them in those situations, but you also need them even if you're going to be hiring a non-family member to be coming in and providing care as well. So what situations do I see where there's a caregiver involved? So a lot of times it happens in two main ways. So the first way is that we have a child who actually has had to quit their job because maybe mom or dad has a lot of doctor's appointments they're traveling to and they're taking them, or it might be that mom and dad require so much care that it just wasn't feasible for them to be working full time. So they might have quit or retired, and this is the main thing that they're doing. So it could be a family member is already providing that care and support. The second situation in which we see it is where we want the individual who needs the care to be staying at home for as long as possible. And again, that could just be there, that's where they're comfortable. So anytime we have a client who has dementia or suffering from Alzheimer's, we always like to keep them where they're most comfortable. And having those familiar surroundings is a great comfort for individuals suffering from that. So to the extent we can keep them at home for as long as possible, it's helpful to the individual. It's also helpful financially for the family to be able to do that. And again, we're talking about situations in which there's a need, maybe there's a spouse that we need those funds there to provide the care. So those are the main situations in which we've seen caregivers needed. More often than not, it's the situation where a child has retired or quit their job in order to provide the care. And so we're setting up a situation where, we might want to be providing some sort of compensation. Now, the one thing I will say is that Pennsylvania has two programs. So know that there is the skilled level care where you can go into a facility and Medicaid can help provide the financial support there to cover that. But another program that Pennsylvania has is the Pennsylvania Aging Waiver Program. It's called the PDA Waiver Program. And that's where the individual is staying at home and skilled level care is coming in to provide the care. So the one tricky thing about this is that if mom or dad has lost capacity, but we still want them to stay at home. So we're looking at what we call the PDA waiver program. We call this home, community-based care. So we want them to stay in the home. Well, in that case, if we're using the power of attorney to execute these agreements, we can't have the child who's appointed as the power of attorney also being the caregiver in that situation. But that's only if they're staying at home and that child is providing the care. If it's something where we're talking about for Medicaid benefits and they're going into a facility, that doesn't apply. It can be the same individual who is the agent signing those admission agreements, but just know that it can't be the same individual, it can't be the same child who signs the caregiver agreement as agent, can't be that same child who's providing the care. The next slide, we want to talk about the tax consequences because I can never go through a whole presentation without talking about taxes. It would just make me a little sad not to have that part of the programming. And it's an important discussion to have. So know that when we do these caregiving agreements, typically we're going to have independent contractor language in the agreements. And we do that because a lot of times the elderly person isn't going to want to treat them as an employee. They don't want to have employment tax withholdings. They don't want to have to do all those things that employers have to do for their employees. But it does create a little bit of an issue between the aging parent in this situation and the child, because from the child's perspective, and from the IRS perspective, they may not actually, in fact, be an independent contractor if this individual is not providing the same type of services for everyone else in the community, at least as an option. So, for example, if I'm my mom's caregiver, I'm not technically an independent contractor unless I'm also giving those same caregiving services to other people in the community. So that's kind of where the conflict comes in. So it's always better and typically we're representing mom and dad in this situation. It's always better for our client to have the language about the child being an independent contractor, but just know that that's not always the best thing for the child, because then the IRS may treat it differently. So this is always a conflict that we have in those situations. So remember, the whole point of this caregiving agreement is to rebut the presumption that this is a gift. So it's almost like Medicaid rules are going up against the IRS tax rules. And so what you have to do is figure out what makes the most sense for everyone. What I'm trying to do is just alert you to this potential issue. So think through that, make sure you're consulting with your accountant, talk through it with not only mom or dad, but also the child, and figure out what works with that. The second thing you have to be careful of are the liability concerns. So for example, when you are a caregiver, sometimes there's a lot of mobility things that you're doing to help that person. So for example, if they're wheelchair bound, you may be moving them in and out of their chair, in and out of the vehicle. And so there is a high risk that somebody would potentially be injured while on the job. And so again, if you're an independent contractor, you don't have that liability coverage, you don't have the worker comp, you don't have unemployment compensation. So you have to think through that if you're the individual who's providing the care. One solution that we've been able to do is that certain businesses or companies that offer caregivers. So for example, in our area, we have like Visiting Angels is one of them. So sometimes we can get a child who maybe has quit their job or retired and is going to be the full-time caregiver. We can go to Visiting Angels and get them kind of under Visiting Angels liability and their employee rules there, so that way the child doesn't have to worry about what are the IRS consequences of actually being an employee for my mom or dad while the agreement says independent contractor, and to also alleviate all these liability concerns. So that's one thing that we have been able to do, is work with agencies and organizations to be able to mitigate those concerns. And again, it just kind of, they bring that child under the umbrella of their organization. And so then they're able to do the proper withholdings, they're able to take care of all the liability, and then it doesn't put the child at risk like it does if you're just doing it privately. So just know that there are things that we can explore to help solve those issues, but it is an issue and we have flagged it as such. And we want to make sure that if we're going down this road, we aren't jeopardizing one party or the other in order to make it work. All right, our next slide just talks about what services. So this is just kind of the language that we pulled from our generic caregiving agreement document that we use. And so it just covers the type of service. So we've just tried to list things like housekeeping, laundry, dishwashing, meal prep, dressing, all of those things that a caregiver might do. We have to outline all of that so that it's all covered under that contract. And then you're also going to see down there, it talks about hours of work and the schedule. So typically we're going to say about how many hours a day, is it something where they're coming in every day for a couple hours in the morning, the afternoon, certain days a week, maybe just Monday, Wednesday, and Friday, or a Tuesday, Thursday schedule. So I know that it sounds like it's very in detail. It has to be, because if mom or dad are ever applying for the PDA waiver program or for Medicaid benefits in a facility, they're going to ask for a copy of any type of caregiving agreement that's done, and it has to be a legitimate contract. And part of the requirements of a legitimate contract is you're outlining all the different things that individual is going to be doing. So we have to say, this is what they're going to be doing. This is the number of hours they're going to work. This is their schedule. Also know that, again, that's where it does create some issues with the independent contractor versus the employee, because one of the IRS requirements for an independent contractor is that the person can't dictate what hours or when someone is working. So for example, if I'm working for my mom can't say, I need you here this time to this time. This is exactly what you're going to do. She can't be supervising me in order for it to be a valid independent contractor agreement. So again, these are all things that we have to work through with the parent and the child who's providing it, not to lose sight again of the goal, because again, the goal here is that if we don't have this agreement in place and there's money going back and forth between mom and caregiver or dad and caregiver, then it's going to be considered a gift unless we have this caregiving agreement. So the other things in the caregiving agreement, it's going to say the employer will pay the caregiver weekly on, blank of each week at the following rates. And so typically it's an hourly rate, and you try to match it at what an organization would charge. So again, it could be anywhere from $20 to $30. Now, that might be a little bit high for your area, that might be a little bit low for your area. So again, usually what we try to do is say, okay, if you did have an organization or company coming in and providing the care, what would be the hourly rate that you would be paying that individual? So again, this is just a range here. I know sometimes that when I talk to clients who are getting those organizations or companies, it might be lower than that. It might be $16 an hour that they're paying that individual. But just know that usually when it's a child, you do kind of want to go for the upper value of the range of hourly fees. And then you also need to keep a caregiver's log that has records of what was done, how long you were there. So again, not necessarily a timesheet, but a record to say, this is what I did on what days, when I was there, how long I was there. Because again, you'd be required to do that if you were a caregiver for a non-family member and you were getting paid. So we're trying to treat it as you would if it were a non-family member. And this is an example of a caregiver log that we've provided for clients. And again, it's just talking about the time of day, what chores did you accomplish, or what were the day's activities related to what you had to do for medical care, transportation, accompaniment, financial and legal matters, household chores, assistance with ADLs, that's activities of daily living. So that's things like bathing, dressing, mobility is in there. So all of those things. And then preparation of meals. So this is an example of what a caregiving log could be. The other things that are going to be in there is that we're just in the paragraph number 5, we're just saying that the employment can be terminated at any time. Number 7, we always like to say what's not acceptable on the job. Now, again, normally if it's a family member, this isn't a big deal, but if you are going to have maybe a grandchild or a little bit more distantly related individual, you always want to have this in here. What are grounds for that individual to be terminated by the person who is paying for the care? And then number 11, I've highlighted this. So this is the language that says that the caregiver understands that an independent contractor is not able to make a claim for unemployment compensation. So again, there's language in the agreement that says, hey, the caregiver is considered an independent contractor for purposes of this agreement. And like I said, I know I kind of talked about that at length, but it's this weird contradiction that we don't want them to have it for IRS, but we want them to have it for Medicaid purposes. So again, just walking that line and figuring out what works best and talking to your legal professional and finding out, again, if there are those organizations that you can come under those umbrellas and then maybe avoid these issues. Okay, so that's all of our fun, boring information that we like to give out first before we go into an example. But I felt like it was important to lay the groundwork about why we do situations like this. So I'm going to try to give you some examples. Now, these are based on things that we see at our office. It's not, specific families, just kind of an example of things we see. So the first is the Jones family. So in this case, we have Janet Jones. She has 3 daughters and 1 son. We've listed all the kids there. One daughter, Jessica, lives with Janet and has lived with Janet for 3.5 years. Now, this is important because our first example is really outlining what we call the caregiving exemption. Okay, so this is not a situation and necessarily there would have to be a caregiving agreement. What we're getting at in this example is that Jessica has been at home with mom providing care for 2 years or longer. The cutoff is 2 years. And the reason that it's 2 years is because we're able to transfer the primary residence. So remember, Janet's living there and so is Jessica. Jessica's been living there for 3.5 years. So we have a primary residence that's worth $300,000. If we were to take Janet's house and try to transfer it to her children, there would be a look back period, meaning that for a 5-year period, that transfer would be available to pay for her long-term care costs. Now, I know it is a primary residence and the primary residence is an exempt asset, which means that if Janet would need care, she doesn't necessarily have to sell her primary residence. and use that to pay for care. But if she does die while she's in a nursing home, then the nursing home can come back and recover against the primary residence. So when we're talking about transfers, I know that the primary residence is exempt, but a lot of times clients want to transfer the primary residence so that it's not subject to that Medicaid recovery lien when they pass away. And if you do that, then it is subject to the look back period. And so this example is explaining that if you have a child who has lived with mom and dad for 2 years or longer, and because they lived in the house for 2 years or longer, it made it so that mom did not have to go into a facility. So if Jessica had not been there, mom would have had to go into a facility 3.5 years ago. So the point of this is that they're saying that because mom never paid Jessica, there was no consideration to pay her, that the primary residence can be transferred to Jessica without a transfer penalty. So mom can do a deed and transfer it to Jessica, and immediately that primary residence is not available for care and it's not available for the Medicaid recovery lien. So this is an example where there is no caregiving agreement. The transfer of the house is considered payment, and I use that in quotes, payment for Jessica's care that she's provided for mom. Now, a couple of things to know about this is that you can't do it proactively. So you can have Jessica move in with mom and say, we're going to go ahead and transfer the house to her because Jessica's going to provide care for the next 2 years. It doesn't work like that. You had to have already made it through the 2 years and then do the transfer. Second thing you have to know is that you are going to need a letter from Janet's treating physician. And what that physician is going to say is that I know that Jessica lived with Janet for 2 years or longer, and because of that, Janet did not have to go into a nursing home. And so we here at our office, we do that for our clients. So if Janet came into our office, we'd actually reach out to her doctor. She'd sign a release. We'd reach out to the doctor, and we would actually give the doctor a letter. And we would say, if you agree with this, go ahead and sign it because it has the particular legal verbiage in it that we need for Medicaid benefits when we're applying. So we'd actually send the letter to the doctor. The doctor would review the chart, refresh their memory, make sure that yes, they agree with that letter, then they sign it and return it to our office. What our office does is then when Janet applies for Medicaid benefits or when she goes into the nursing home, we have a copy of the deed that showed that Janet transferred it to Jessica, and we have the doctor's letter that says that Janet was in a situation where she needed assistance with the daily activities of living. Jessica provided that for 2 years or longer. And so because of that, Janet didn't have to go into a nursing home. And the beauty of this example is that that home can be transferred. There's no look back period. There's no gift at all. You're allowed to do this under Pennsylvania law. And so it surprises me how often I run into this situation and people just don't have any idea that they can do this. And so I always like to ask, especially if a child is bringing mom or dad in, who lives there, what's the situation like at home? And it's really important to talk about. And so you want to make sure that you're thinking through these options. The other thing I want to talk about is in this situation, we might talk to Jessica, Joyce, Janice, and Josh. That's a mouthful, the 4 kids, because although Jessica has provided the care for mom for 3.5 years, mom might only have the house. That may be her only asset. And so sometimes people like Janet will say, well, I do want Jessica to get the house, or I feel like, she has earned the right for the house, meaning it's transferred to her. But Janet may say, but if Jessica ever sells it, at that point, I would want her to share the sale proceeds with her brother and sisters. And so in that case, what we do typically is we recommend a family agreement. And the family agreement is actually going to be between the children. And that's usually where we like to possibly get another attorney involved to maybe represent multiple children, just because we represent mom and we did the deed, but we might recommend a family agreement that just outlines the fact that yes, Jessica did live at the house, provided care, so the house is being transferred. It could be something where, so the family agreement works in 2 ways. So the first is that Jessica lives in the house, stays in the house, but if she'd ever sell it, she has to split the sale proceeds. The other way that family agreements are done is that when mom passes away, Jessica may the agreement may say she has to sell the house, and then she gets maybe a higher percentage of the sale proceeds. But this is a great way to transfer the house without having a transfer penalty, without having a look back period, without having to have a caregiver agreement. So this, we were able to accomplish everybody's goals in that way. Now, the last thing I'll talk about with this example are the tax issues. So know that when Janet signs the deed over to Jessica, again, there's no consideration in there listed because Jessica's not actually paying for it. She's already paid for it because of all of the care she's provided for mom. So for IRS purposes, again, although it's considered compensation for Medicaid purposes, the question is, what is Jessica's basis in that property? And, if she ever sold it, what does that mean? So the first thing to know is that if it's transferred to Jessica's name and she lives there as her primary residence for 2 out of 5 years and she sells it, then the sale proceeds are exempt from income taxes as long as it's less than $250,000 if she's single or $500,000 if she's married. If she's not living there 2 out of the last 5 years once it's transferred to her, because again, you have to be an owner in order for the 121 exclusion. So if it hasn't been transferred to her, she lives there 2 out of the last 5 years, she doesn't qualify for that exemption. And so the way the IRS looks at this is that if Janet gifts it to Jessica, now again, it's not a gift for Medicaid purposes, but it would be a gift for IRS purposes. So in that case, Jessica does get Janet's carryover basis. So what that means is that whatever Janet purchased the house for, that becomes Jessica's basis in it. If she sells it and it has not been her primary residence for 2 out of the last 5 years, then she most likely would have some capital gain that she has to pay on that. Now that's assuming 2 things. So the first thing is that the real estate market values have gone up. So if for whatever reason that's not the case and the value has gone down from what mom purchased it, then obviously it's a loss. But just know that you want to think through the tax consequences. And so anytime we're talking about this example with our clients, we're talking about, yes, the Medicaid ramifications and the benefit of being able to transfer it without having the look back period or there being a transfer penalty. But we're also trying to think through the income tax implications for both Janet and for Jessica. So that's example number 1. Here's a little picture, because I love pictures. So in this case, we transferred the deed to Jessica. And then if Janet needs to go into a long-term care facility, the property will be sold. So in this case, in the agreement, it actually said that. And the reason why that was in the agreement is because in this case, mom was actually in a facility that did not accept Medicaid. Now, we talked to the kids about how they have the option of either A, transferring mom to a facility that accepted Medicaid benefits, and then again, the property is protected. But if they would choose to be in a different type of community that doesn't accept Medicaid, that's all private pay, we wanted the family agreement to say that the property could be sold. And then it would be transferred to the other siblings. So that was just an example that we used. And again, if mom is not in a facility, like for example, if she's in a traditional long-term care facility and Medicaid is an available resource, then you don't have to have the provision in the family agreement about selling the house. You can leave that out. In this case, the family specifically wanted it because they wanted to have the option to keep mom where she currently was, and she was in a facility that did not accept Medicaid benefits. But if mom ever went to a hospital and then was transferred maybe into a skilled facility where Medicaid was an option, then they wanted to be able to get it exempt from nursing home costs. All right, let's go to case number 2. So this is the Tanner family. So let's see what facts the Tanner family has. So we have Dorothy Tanner. She's a mother of 2 daughters. We have Connie and Eliza. Dorothy is living with Connie. And their family agreement on which Connie and Sam, so Sam is Connie's husband, would provide a certain number of hours per week to take care of Dorothy. So a couple of things in this example you have to know is that Dorothy does have a primary residence. Now the example that we pulled, like I said, we pulled it from a couple of different ones, but the example that I wanted to make sure in this one to bring up is if the primary residence is not in the same county. So let's say mom, Dorothy, moves in with Connie and Connie is in Franklin County, but maybe Dorothy is in Bedford County. Her house is in Bedford County. In this case, why we have to have the caregiving agreement, mom's moving in and Sam and Connie are providing a certain level of care. So again, if Dorothy would just be paying Connie and Sam, they either have to say, well, it's rent and they'd have to claim it for income tax purposes, or they're going to have to say that it's part of a caregiving agreement, because otherwise the presumption in Pennsylvania is that's a gift. So in this case, what they decided to do is to not charge a rent. So no, in this case, that would have been an option. They could have done like a rental agreement and charged rent to mom, or had a rental agreement and had mom pay certain utilities. That would have been another option. In this case, they chose to do a caregiving agreement. So, and this works a lot if families have somebody staying at home. So if we say in our example that maybe Connie works from home, a certain number of hours a day, this would be a great situation when that would work. So the caregiving agreement does have to provide that, all of those stipulations, what hours, what's the task that somebody's going to be completing. And again, the benefit there is that then any money that Connie and Sam are receiving is not considered a gift for Medicaid purposes. Now, the one thing that I did in this situation, talk to Connie and Sam about was, you know what? Dorothy can gift you $500 a month or less, and it's not considered a gift. That's an exception for Medicaid purposes. So know that when we're doing a caregiving agreement, maybe we talk to Dorothy about how she can transfer maybe $450 a month. Now that's total, that's not per person. She can transfer $450 a month to Connie and Sam as a gift, but if she'd be transferring anything more, then it would be considered a gift for Medicaid purposes, and that would be problematic. So we would account for that with a caregiving agreement, and maybe, it's not as much an hour because they don't need as much because they're getting the $450 gift every month. So you can use it in conjunction with that monthly gifting amount. So, and if we would have husband and wife, so if Dorothy had a husband, know that it's $500 per giver, meaning Dorothy could give $500 or less a month, and a spouse could give $500 or less a month. Now that's per giver. So Dorothy can't give Connie $450 and then turn around and give Eliza $450. It is $500 or less total per month. And you also have to do it per month. You can't wait till the end of the year and then say 500 times 12 and just write a check out for that. You have to be doing it on the monthly basis. So in this example, we used the gifting amount, and we chose $450 a month in conjunction with a caregiving agreement that just said that, Connie and Sam were going to provide this number of hours a week, and this is what they were going to be paid. What we did with a primary residence is we did then transfer it into a trust. So the reason that we did that is that, in theory, Dorothy is going to be living with Connie and Sam for a period of years, so she's not going to have to go into a nursing home. So if we transfer the house into a trust at the same time we're doing this, the benefit is if the house is owned in the trust for 5 years or longer, then technically they could sell the house, they could do whatever they wanted with the assets inside that trust, and it would be protected against long-term care costs. So sometimes what this example is designed to show is that sometimes we have situations where we use a trust in conjunction with a caregiving agreement, in conjunction with the monthly gifting amount, so that we can make sure that we're protecting assets against long-term care costs. And the way this trust works is just that Connie or Sam would be the trustee. Actually, mom, Dorothy, could also be the trustee if she wanted to. And then the successor would be the sister. And what happens is when mom passes away, it would go 50-50 to Connie and Eliza. And we would transfer mom's real estate in here. It can be real estate, but it can also be any other asset. And again, the benefit is because Sam and Connie are going to be providing that care under the caregiving agreement, and then in addition are going to be receiving that $450 a month, we're going to be able to provide care through the look back period and be able to protect the assets. All right, let's go to our example number 3. So this is the Washington family. So Elizabeth Washington is a widow, and she sells her primary residence. She then gifts her son Todd and his wife Cindy $55,000 toward the purchase of a house where Elizabeth will also live. And it's funny, I've been practicing since 2008, and I didn't see any of these when I first started practicing. And now I'm seeing more and more of this situation, which I feel like is a good thing because I feel like we've kind of gotten to the point where families were very spread out and you weren't seeing a lot of family members providing the care. And we're still seeing that, but we're also seeing a large number of families where maybe mom is selling a house or dad is selling a house and contributing some of the sale proceeds to either purchase a house where maybe there's going to be an in-law suite, or maybe building a house that has a place, in this case for Elizabeth, to stay. We have actually had, oh goodness, I think 2 clients in the last year where we've talked about this type of situation, because it's important to talk about how to protect that. So when mom gives the $55,000 towards the purchase of the house, remember the presumption is in Pennsylvania that that's a gift. And so that would affect mom if she ever needed long-term care. Plus it would potentially put Todd and Cindy's house at risk. And so we have to think of how can we do this? How can we protect both mom and Todd and Cindy? So in this case, what we're doing is we're addressing the long-term care concerns and the fact that Elizabeth gifted the $55,000 toward the house. So what we do in this case is, this is an example of some language from the deed. It's easier for me to talk about it when we actually have the language in front of us. So what's going to happen is Elizabeth is going to have a life estate in it. She's going to be considered a life tenant. So what we do in the deed is we actually say for $55,000, she's contributing, she's buying this life estate or this life tenancy. And then it's saying in there that, it's preserving her right to live there. So that means that it's protecting her, because Todd and Cindy can't evict her at any point. They can't say, oh, you can't stay here. She's now contributed that money towards the, like I said, either purchase of the house, or right now it's, building houses. We see a lot of that. And so by putting it in the deed with the consideration, what we're doing is we're saying this is not a gift. This is a actual fair market value transaction. So the only risk that we have with this is if the 3 parties, if Elizabeth, Todd, and Cindy decide to sell the house, a life tenant is typically entitled to a certain portion of the sale proceeds. So that would be the situation in which we'd have a concern, because then a certain portion of the sale proceeds would be available for Elizabeth's care. However, if that's not the case, and this is her primary residence, maybe she has an in-law suite connected to the main house, this is her primary residence, she's paying adequate consideration, it was not considered a gift. And the nice thing here is it's not subject to the Medicaid recovery lien, because it never goes through Elizabeth's will, because the deed is going to say that when she dies, it automatically goes to Todd and Cindy, son and daughter-in-law. So we've been able to protect this property for Elizabeth, but also when she passes away, Todd and Cindy don't have to worry about the Department of Human Services and the nursing home coming back on this value. So I wanted to show this example because I think more and more families, if they knew that this was an option, would consider it. So for example, at our family, I think I've talked about this before, I have 2 older sisters and 1 younger sister. And for a while, my younger sister did talk about it, and they may do it sometime in the future, had talked about, maybe we'll build a house and have an in-law suite for mom and dad. So I think that if more families knew about this as an option, maybe they would consider it. So I always want to make sure we're putting out the information that might be helpful. So this is a great strategy for mom to sell her current house, give a portion of those sale proceeds to son and daughter-in-law, and help them either purchase a house or build a house where she could also reside, and we're protecting both parties there. So the benefits of a life estate deed is that the primary residence is an exempt asset, like we talked about. So a nursing home can't force the sale of the primary residence if Elizabeth would ever need long-term care costs. It does protect that gift of the $55,000 from the look-back period, because it's not really a gift then. Mom is putting, a portion towards the fair market value of the house. It protects the house from estate recovery, because automatically it's going to go to Todd and Cindy when Elizabeth passes away, so we don't have to worry about after the fact. It also makes probate nice and easy, because the house won't go through the probate process. It'll automatically go to Todd and Cindy as well. And again, just that last point, which we talked about, is if the home is sold, then she would be entitled to a portion of the sale proceeds since she had a life estate. But usually in this case, the families that's not something they're going to do. And so we don't have that to worry about. Okay. So that concludes today's seminar. What you can do next is if you have questions or concerns, you can always call our office at 717-655-2676. We always offer free initial consultations at our office. And for anybody who hasn't checked out our YouTube channel, you can either go directly to YouTube and look us up, the Law Offices of Samantha Wolfe. You can also go to our website and we have a link that takes you directly there. We had taken the summer off from virtual seminars, but we're back doing them. And our next series or our next grouping that we've been doing are all examples of things that we see in our office. So know that you can find the more traditional virtual seminars that just have information on our YouTube channel, but you can also find these that do give examples of planning strategies that we've used for our clients. Our next seminar is December 8th. From 12 to 1 p.m. And we're going to focus as the year closes out on charitable planning. I always think Christmas and the holiday season is a great time to do that. So we're going to talk about charitable planning. Can you spare some change? So we're going to talk about different ways that you can include or incorporate charities in your planning. And it's things as simple as updating designations, or it could be using a trust. So we're going to cover all of that at our next seminar. You can register by emailing Amy at her email address. You can call us at 717-655-2676. You can also click on the link to our website and register there. And I know Amy's been trying to send out texts letting people know and emails letting people know, so you can always respond with those and let her know if you want to register. You can also respond and let her know that you don't want her to text anymore and she's happy to take you off the list there. All right, I think that we're at the point where we can ask some questions. So let me just close this out. So Jess, if you want to stop sharing the screen. So I'm Samantha from the Law Offices of Samantha Wolfe, and you're always welcome to give us a call at 717-655-2676. And thank you for joining us for this month's virtual seminar. We hope to see you next.